Hello, everyone, and welcome to the first book talk in our spring series on reimagining the Latinx experience. Before I introduce Professor Olivas, I wanted to acknowledge a few individuals who've been extremely important in making this book talk series possible. So first of all, I want to thank my research assistant, Isabella Ordorica. She will be joining us shortly. She had an interview, and so she'll be here momentarily, but it would not have been possible without her invaluable assistance. I also want to thank Rabe Kadri and Aaron Hebert, who have really provided us with very significant support, both in setting up the webinars and publicizing them. And I also want to acknowledge Jillian Henry, who last fall when we launched this series really did a tremendous amount of work on the logistics. I would be remiss if I did not also recognize Dean Richardson and the UCI School of Law for the generous support of this series, as well as Ajay Marotra and the American Bar Foundation, who have also provided very significant support. Just a few ground rules. After my introduction, Professor Olivas will be speaking, and we will be taking questions through the chat function. And my assistant, Isabella Ordorica, will be monitoring the chat function so that we can try to pose as many questions from you as possible. And then we'll close as you know at the end at 1 o'clock, and I'll let you know about upcoming talks in the series. So let me turn now to the main event, which is the talk by Professor Olivas. And he is going to be talking about his book, Perchance to Dream, which is a legal and political history of the DREAM Act and Daca. Professor Olivas has a very distinguished career. He was the William B. Bates Distinguished Chair in Law and Director of the Institute for Higher Education Law and Governance at the University of Houston Law Center. And he's been a very busy academic. He's the author or co-author of 16 books, very, very impressive, including this one. I just wanted to mention a couple other titles. Like he wrote Colored Men and Hombres Aquí, which was published in 2006. And he did an anthology, a wonderful anthology in 2007 on education law stories. And in 2012, he wrote a book called No Undocumented Child Left Behind. I also wanted to mention that he wrote Suing Alma Mater, and that was the winner of the 2014 Stephen S. Goldberg Award for Distinguished Scholarship in Education Law. And in 2017, he had the singular honor of having a book published that has collected together and recognized his original scholarship. And the book is Law Professor and Accidental Historian, the Scholarship of Michael A. Olivas. And there were chapters by 20 scholars about Michael's very important work. He has also served on the editorial board of more than 20 scholarly journals. And in 2011, he served as president of the Association of American Law Schools. And then in 2018, the association actually gave him its triennial award. It's a huge honor for his lifetime service to legal education and the law. He's also been elected to membership in the American Law Institute and the National Academy of Education, the only person to have been selected to both honor academies. He's received many, many honors, too numerous to mention here, but I did also want to let you know about one that I think is very significant, and that is that the Law Center chose to honor him and his wife, Agustina Reyes, by naming the Olivas Reyes Reading Room in the new O'Quinn Law Building. Now, it's not all work and no play. Professor Olivas also is a lover of rock and roll, and he has a regular radio show on the law of rock and roll. And also he has a briefcase podcast that's about entertainers dying without will. So he has another side to him. But today we're going to hear from him about his book, Perchance to Dream. Thank you so much, Professor Olivas, for joining us today.
Thank you. I'm very pleased to be here and to have a chance to talk about the book. I talk about it every day, whether or not people are listening. So I'm always glad to have an audience as well. Isabella, welcome back. I hope the interviews went well. And congratulations on being named editor-in-chief of the Law Review. That's a very singular honor.
Thank you so much.
Yeah. You're so accomplished, you must be from New Mexico originally, somehow.
I have family there.
Well, see, I knew that as
There
well.
was a connection.
Because so much has happened since I published the book, and I published it on a Sunday, and the Supreme Court decided it on a Thursday, and I predicted how they'd come out, and they actually did so, but I was holding my breath for all 4 of those particular days. So what I'm going to do today, in large part because my life has been built around 3 things. It's in part because I studied to be a Catholic priest for 8 years, and so things fall into 3s for me very easily. But what I'm going to do today is talk very briefly about the antecedent case, the case of Plyler versus Doe, which both Professor Moran and I have called the high watermark of immigration law. And then I'm going to talk about the DREAM Act, which preceded Daca. And then I'm going to talk about Daca itself and the Supreme Court cases and what's happened since that time. And when I started out teaching in 1982, I think it was the same year that Professor Moran was hired, but she practiced for a couple of years and then joined the faculty of Berkeley. So I think we've actually been teaching just about as long as each other. And our careers have overlapped, and our friendship, of course, has endured that entire time. But in that particular period in 1982, I had just moved to the University of Houston, and Plyler versus Doe was announced. I remember cutting class at Georgetown Law School when the president of MALDEF, who was trying that case, had a fundraiser. And of course, I was a law student, so I didn't have much money to give. But I remember coming, and a bartender got sick, and so I served bar for the first time in my life. Fortunately, most of the people there just like beer, and so all he's doing was handing out beers. But I remember it very, very well. And so when the case occurred, which had been tried partially with a case that occurred in Houston at the same time, that was consolidated, I was very glad to go into the heart of what I considered to be sort of enemy territory in a long way. When I was growing up, my grandfather once told me, Michael, ten cuidado con los tejanos porque son todos desgraciados y no tienen vergüenza. And it turns out that New Mexicans and Texans are natural enemies by some parts. So I tell people that I spent 38 years doing missionary work in Texas. You see from recent events, it didn't take very well. But the point is that I was parachuting into Houston, a town where I had never been before. And all of a sudden, there was this law on the books that no Texas school district could charge tuition either to children of undocumented parents or to undocumented children. Because this isn't about Plyler, I just want to very briefly summarize that, but to say that the reason we had so many, such a substantial number of successful undocumented college students who are really the focus of DREAM Act and DACA was because of Plyler versus Doe, which said that they could go to school, they couldn't be charged tuition. And as long as they had residence in the school district, which a couple of Supreme Court cases following made very clear, this was essentially about not only immigrating to the United States and the purposes for which parents did so, but it was about issues of place and duration and domicile and residence and even duration. How long you lived in a place, where you lived often determines benefits. And of course, that's a fairly common categorization of how you distribute benefits. But school districts, particularly public school districts, require that the parents live within those school bounds. And so the Supreme Court held essentially that the state had no legitimate reason for charging tuition, and that in many ways, the United States immigration policy at the time gave what they called inchoate permission, a term that I always had to look up because it's not one that sort of rolls off the tongue. But because of that, and because many of these kids would eventually find their way through legalization, a prediction that turned out to be true for a while, but then not much after that. There could be no, and because you couldn't look out in a classroom and tell who was documented and who wasn't. And in fact, many families then and now have mixed immigration status. The older children are born in the home country, let's say for our purposes, in Latin America, although they come from all over the world. And then the younger kids were born in the United States, and they're the ones who have birthright citizenship. And so you'll find even in some families, those who are vulnerable, the parents in particular, perhaps the older kids, and the younger ones are almost always citizens because they're born in the United States and then remain. Well, that dynamic has established an incentive system for students who were either undocumented or whose parents were undocumented, even though the family may have lived in the shadows, for them to do well in school. In the first 2 years after Plyler in the Houston School District, which was the 4th largest school district in the country, had over 220,000 students, and my the woman I fell in love with and married was president of the school board at the time, so I had all kinds of access to information into these students. That led to in 1 year, 22 of the high schools had either the salutatorian, or the person who was the number one in their class, the valedictorian, were undocumented. And these remarkable students were then encouraged to attend college. And so they kicked the problem of Plyler upstairs to the colleges. And of course, these students had to pay tuition, but the question was, were they eligible for in-state tuition, in-state residency, or did they have to pay out-of-state, or in some cases, international? Well, believe it or not, if you read the book and look at all the court cases that I mentioned in there, the book, by the way, is available in fine bookstores everywhere, just so you know. These students were challenging public institutions, particularly in Texas and in California, where most of them were, to allow them to have in-state tuition. And so there's an entire generation of Leticia A students and other students in the Martinez case in California, as well as in Texas. And these students won as many cases as they lost. And sometimes they would go back and forth depending on who the leadership was, or who the admissions officer was, or how they were able to document their time in the state for purposes of being an in-state tuition. And a number of people have asked me, Michael, why do almost all these state residence requirements require 3 years of schooling when normally you just need 12 months of schooling in order to attend as an in-state student? So in Texas, when I came in 1982, in-state tuition was $4 an hour. And then after it changed the next year, it was tripled to $12 an hour. And in-state was X and out-of-state was 10X. So the difference between $4 and $40 is substantial. And so these students really had every incentive to try and establish in-state tuition. And so in 2001, I worked with a small group of MALDEF lawyers and board members to try and get the state of Texas to allow students who'd lived in the state to become in-state tuition eligible. They had been, but it had been very uneven. The two-year colleges, which at the time didn't charge tuition, just like they didn't in California at the time, were letting people in as long as you lived in the district and as long as you'd been there for long enough to have a permanent address. And so it was very uneven, but essentially we decided on 3 years because the state of Texas lawyers with whom we were negotiating said, well, how about 10 years? I said, well, that's a long time for a 17-year-old who's applying to college to be in Texas. Normally, if you're born in the United States and you move from Louisiana or Illinois or Texas to another state, it's 12 months. So I said, how about a compromise? Let's say 3 years, because every public high school in Texas has sophomores, juniors, and seniors. And so if you come for high school and be there for 3 years, that should be enough. I said, besides that, they aren't coming from Mexico or wherever they were coming from in order to go to high school or go to school at all. The parents were coming for work and for a better life for their children, which of course meant education because it was in the state's interest. And they said, 3 years seems reasonable as long as everybody else has 12 months. I said, well, of course. So we did that. So that's how people have asked me, how come every state other than New Mexico, where I also helped write the statute, but there I convinced Governor Bill Richardson, himself Mexican-American and a good friend, who wrote the foreword to the book, which I remind you is available in fine bookstores everywhere. Because of that, we have 3 years in virtually every state. And now we have it in almost 30 states. And the others, for the most part, can make other provisions. And MALDEF has a remarkable run of successes, having lost only in South Carolina on a permanent basis. And the book does indicate other cases as well. So I'm gonna move from that, although I will take all kinds of questions that people that might have through the chat function. Now that Isabel is back, we're gonna ask her to summarize those and be sure and give priority to non-Tejanos, if you would, Isabel. And because of your own family roots, New Mexicans moved to the top of the question line as well. So that brings us to about the year 2001, because of course, 2001 is 9/11, and the first state to sign into law an in-state tuition bill was Governor Perry, who had taken Governor Bush's place when Governor Bush became President Bush. And so he signed it into law, and then 9/11 occurs, and it began to, because of that, even though there was no connection, it just meant that the likelihood of immigration reform at the time was really cut short because of 9/11, which concentrated on national security and made it simply threw off all the immigration bets that had been launched. I remind you, by the way, that in the meantime, in 1986, the Immigration Reform and Control Act had been enacted, which legalized a lot of these kids and their parents. And so it wasn't as much of an issue, but then in 1996, when President Clinton had a Republican Congress, they held his feet to the fire, and he was forced to sign two very restrictionist bills, one called PORA and the other one IRA. And they stand for and to distinguish that from the other one, that's what they stood for. But essentially, they made it much more difficult for people not only to remain in the United States or to enter legally, but it cut back on many of the other benefits. At about the same time, the state of California had changed its mind and was not letting public institutions at all three levels, either the community college or the Cal State or the UC system, give in-state tuition. That went back and forth with a number of cases, and in 2007, the Proposition 187 was passed, and even after it was resolved, the one thing it did do was strike down in-state tuition. And so it took several more years for the state to come up with in-state tuition. And of course, since that time, it's become extremely generous, including allowing students access to Cal grants and other federal, other state financial aid, as well as even loan programs and admission. And a substantial number of these kids, of course, have gone to college, including some who are probably on this call, because I find very successful people who've navigated the state DREAM Acts that were enacted during that period of time. Now, in 2001, there was also the introduction of the federal DREAM Act by Senator Ted Kennedy and Republican Senator from Utah, Orrin Hatch. And I'd always assumed, because these two guys were bookends, that is, famous liberal and a famous conservative, that their co-sponsoring it would have suggested by all political science standards that it would be enacted into law. And in fact, I started taking bets for that, and I'm confident that I supported at least one of my favorite Tex-Mex restaurants in Houston, Ninfa's, paid political announcement there, because I lost all these bets. I thought for sure it was going to be the case. And of course, Congress has not yet ever passed it. Now, the truth is, in 2007, they came 5 votes shy. And I spend some time in the book talking about how that occurred, because Senator Kennedy was on health leave and died not long after brain surgery. He had brain cancer, and others who you would have thought would have been supporters, like the liberal Arlen Specter from Pennsylvania, who became a Democrat in 2008. But he said, no, he said, I don't want to support this because if we pass this, it will block comprehensive immigration reform. My argument to that was, of course, that if you have Daca or the DREAM Act enacted, that's the easy cases, because these kids are ours. They've been educated here. These are the kinds of kids who actually are already in college, and you want them to become citizens. Now they've got no pathway to permanent residence or citizenship. So I said it's the opposite of stifling comprehensive immigration reform. This would make it more possible. And once they turn 21, they could have also advocated for their parents and given benefits back to their parents in eligibility. But it died. And a couple of very disappointing cases. Senator McCain, who'd been a supporter of it, was running for the presidency, so he backed off. And a couple of, Senator Boxer, a famous liberal from California, was back in California because of forest fires, and she was attending to that. And we just couldn't get those last 5 votes. It just broke my heart that we came so close. Now, since that time, the House has passed it several times, and it's just never been able to have both chambers. And you may recall that in the Trump administration, he blew hot and cold. Sometimes he said, I love DACA, and then sometimes he'd say, well, they're all communists. And so he never did support it. And of course, he sent out the signals that he wouldn't support it. So the Republicans who were in charge were never going to take it up because he had not indicated his support for it, his permanent support. So in 2012, after many years of President Obama's having enforced deportation and removal, a lot of people called him the deporter in chief. I refused ever to use that curse word because I thought what he was trying to do was to build the legislative case for permanent reform for dreamers. And if he showed that he could remove people who were criminal in the United States and stop border enforcement or beef up border enforcement, that the trade-off would be that Republicans would support the DREAM Act. Well, they never did, and so he deported a record number of persons. But what he did do in 2012, at the behest of 4 law professors who wrote him, including Professor Motamura at UCLA, who chaired the group wrote in and suggested that he use prosecutorial discretion, the kind of discretion that any president uses, just like if you decide you're going to emphasize street safety, so you start enforcing jaywalking, or you say, well, we're not going to seek jail time for people who simply have a joint as long as it's lower than the amount required for possession or distribution and so forth. And so the normal exercise of discretionary prosecutorial discretion led to DACA, the deferred adjudication for childhood arrivals. And DACA was immediately challenged, but it won all of its cases for the first 2 years or so. And then President Obama decided to double down, and he also added DAPA. And DAPA was for parents who had undocumented children. And I knew as soon as he did that, and I had advised one of his advisors that this was a bridge too far for most people, because what he was trying to do there was genuinely make immigration reform by presidential decree. And I just thought it's one thing to allow kids to go to college. It's another to let their parents have a pathway to legal citizenship. And while I, of course, would do that, if I were czar for the day, I would have thrown that down and said, here, all of you take this and overturn me if you want. Well, what happened was Daca had been enormously successful. It ended up with, by the time that the Trump administration took over and began efforts to slow it down and then to stop it and to try and rescind it, it had almost 800,000 students, all of whom had paid fees, all of whom met the requirements, which required that you not only not have felonies and so forth, of course, but you not even have serious misdemeanors, which for most college students means public drunkenness or DWI, or in many cases, because these kids couldn't get driver's license, driving without a license, and et cetera. So you couldn't have any of those, but you did get not only EAD, employment authorization rights, so that you could work, but you also got a social security number, and the ability to pay into social security. And you also got, and this is a very important feature, you got lawful presence. Now that's not the same as lawful status. Lawful status is what you have when you're in the country with permission and you entered with permission and you can become a permanent resident and then you can become a citizen. But what this did do is it stopped the deportation clock on all of these students. So they could, the federal government would have the burden of proof to deport them, to say that they were deportable, when in fact they were not. In fact, it was so generous that they could leave the country under a concept called advanced parole, and they could return to the country as long as they had permission. So they would do study abroad, they could go home to their abuelita's funeral, they could, as long as they did so with permission, and as long as they kept their nose clean and abided by all the rules. So it was an enormous success. Not only did it pay for itself, but immediately these kids began to succeed in college, just like they had back in the day when they were getting in-state tuition at Cal State LA and all the other schools, and in the Houston School District, where they had simply had all this striving and all the immigrant positive features as well as character, and understood that their parents had sacrificed and were living in the shadows for them, and that they could achieve. Now that was the one downside of Plyler versus Doe, in my view, was that the language, in order to allow the children to stay and to remain in school and receive those benefits, meant that we demonize the parents. If the kids are inocentes, then somebody's got to be the bad guy. And who would be the bad guy? It wouldn't be the school districts charging tuition. It wouldn't be people who had nativist immigration practices. It wouldn't be Joseph Arpaio. It would be the parents who brought them there. And this still has some demonization. And I think that the knocking down of DAPA was an example of that. That is, that the parents who had citizen children were not allowed to alter their own undocumented status because they were the villains in this larger narrative. A narrative that, by the way, in my view, hasn't shifted, although it's been very interesting to hear the new administration and to read its plans. So I don't want to jump forward to that. I want to say just a couple of things about the Supreme Court cases having to do with DACA. Now, when some of you may not remember this because it's ancient history to you, but Supreme Court Justice Anthony Scalia died in his sleep at a quail ranch in Texas. Now, my grandfather was right. Son todos desgraciados y no tienen vergüenza. He dies there. By the way, it was the same quail ranch where previous Vice President Cheney had shot that guy in the face. Same quail ranch. In memory of that, my wife and I now live in Quail Run, a condo complex here in Santa Fe. So, but I don't go shooting at quail ranches. So that left a 4-4 status in the Supreme Court. And by that time, the case that was challenging the constitutionality of DACA that came from a Southern District of Texas case that Judge Hainan presided over. And he had telegraphed his findings on this, and the Fifth Circuit upheld him when he said, this is not constitutional. And so it went forward. But then when Daca was heard by the Supreme Court, he said, I'll retain jurisdiction over this case, but because of the reliance interest of 800,000 students, I don't want to end it. I don't feel that a judge should do that. I think it's a statutory matter, and I'll wait until until it all plays out. So he said, I don't want to be Humpty Dumpty putting the eggs back together again. And it'd been so long since I'd sort of forgotten what Humpty Dumpty meant. So I went and looked it up, and I said, even though I disagreed with him and his decision, I thought it was very sporting of him, very good of him to hold off and retain jurisdiction while it continued to play itself out, especially with the change of administration. So a second time, the case so it ended up upholding the Fifth Circuit, which had ruled along with him that there were problems that President Obama had exceeded his discretion. Now, I kept saying, what about the Administrative Procedure Act? He did not. It was not inappropriate. He was not giving status. These people were ineligible for Title IV federal financial aid assistance. They were unable to change their status in any meaningful legal way. Turned out there was a couple of exceptions, but it was always very dicey, and most were unable to do so. But at the same time, by my count, and I think I kept count of this pretty well, there were fewer than 24 of the 750,000 who lost their eligibility for DACA, either by leaving the country and not getting permission to come back, or by flunking out of school, or in one case in Georgia, someone who got caught driving even though she didn't have a license. And the reason she didn't was because DACA and undocumented persons are ineligible for driver's licenses in Georgia. And so she was caught and was removed ultimately. Now, very, very few, and let me just tell you, for those of you who study legislation and regulatory issues, this is a remarkable sign of success. It not only started up in 3 months and was full blown with what would have been millions of them had it not been stopped after 4 years. And so the Trump administration comes in and says, we're going to freeze this. And so they began not reissuing continuations, by not allowing new folks to come in, by revoking the advanced parole so you couldn't leave the country and come back. And they said, we're going to shut this down. Well, it turns out, if you're a movie fan like I am, this is the gang that couldn't shoot straight. They didn't use the APA in trying to shut it down. And all he would have had to do, and I hesitated to say this during the 4 years of the Trump administration, all he had to do was make a notice and comment. He could have, his lawyers could have said, here's the reasons why we want here's our plans. We want your responses to these. We'll take them. And then they would have ignored them. And that would have been perfectly legal for them to do. They didn't even do that properly. And so in a 5-4 decision, after Justice Gorsuch had been appointed to take the place of the late Scalia, it was 5-4, and the Chief Justice wrote this, and he said, look, you could use the APA, but there's a reliance interest here, and you haven't made the case for it. And by the way, they had just done the same thing two months earlier in the census case, where they had also completely ignored the APA and tried to start requiring immigration status questions. And of course, both of these then were studiously ignored by the Trump administration. They just sat on it until MALDEF and other groups went back into court, and they went to the trial judge. This was not Hainan, this was a different case. And the judge, Nicholas, said, you've got to go forward with this. You have been enjoined, and we insist. But by the way, they also switched it to, instead of the 2-year renewal period, down to 1, which did 2 things. It meant that you had to sign up twice as long, twice as often, and it would cost more because the price was still per renewal. And so they said, nope, it's got to go back to the status quo ante. And for those of you who are looking that up in the books, what it really means is you got to go back to what it was when it was frozen. And that allows new people applying, and it allows, you don't have to do advanced parole because that was simply an administrative decision, but they have employment authorization. Now, during this time, there's also employment authorization issues where at least a dozen companies, like Nationwide Insurance and more recently Exxon, have all said, well, this is just temporary work. Well, employment authorization is by its nature temporary work. And so MALDEF went in and has won all but one of those cases. And so every inch that was gained had to be defended by the lawyers, and usually by MALDEF, but there are other groups as well, Casa de Maryland and other groups. And immigration lawyers, even though Attorney General Sessions called us the dirty immigration lawyers, that's become a sign of pride. It's like a scarlet D that all of us wear because we're the ones who have thrown ourselves into the breach here and thrown sand into the gears and continued to try and keep these kids in the United States where they are moving forward. Now, I want to take one little sidetrack, which is chapter 6 in the book, which I no longer have to remind you is available in fine bookstores everywhere. And I will end on this particular point. And that is that it completely changed how states that gave licenses, either from low-end occupational licenses like being a nail technician, or my favorite, a bunghole operator. One summer I was a bunghole operator at a Budweiser brewery. That's where you take a bung, a cork, and you hammer it into the place where you fill up the beer in the keg, and that's a bunghole operator. They're licensed, believe it or not, in the state of New York. I just sort of went in and schlepped. I was, making union wages, and so I thought it was a great job, even though I don't drink. But because of this, and at the high end, what happens if you're a lawyer? I had 4 students of mine who were research assistants at the University of Houston Law Center over the years who were undocumented, and I helped them arrange in-state tuition. But then the state of Texas wouldn't allow them to practice. So they went to a couple of states that I'm not going to mention, and they practiced there, and one decided to become a admissions director and so forth. But here's what federal law says about that. A state may provide that an alien who's not lawfully present in the United States is eligible for any state or local public benefit for which such alien would otherwise be ineligible, only through the enactment of state law after 1996, which affirmatively applies for such eligibility. So they don't want a state simply to go by what they've done before, but if you affirmatively pass a law saying that these students can get in-state tuition, you might even do what California did in the Martinez case, where Sergio Martinez had graduated, but he was undocumented. His father was a permanent resident, but there was a 17-year wait. And so he couldn't transfer that eligibility for his son. But his son went to graduate school, passed the bar, and presented his credentials. And the state Supreme Court said, well, there's this section 1621 and 1623. Well, I think they misread it because it says if you pass a law, you can do this. But so what they did was the state of California passed a law for Sergio Martinez. I'm sorry, I say Martinez, Garcia. That's a New Mexican mistake. We're mostly Martinez's here. Sergio Garcia, not to be confused with the same Sergio Garcia who dated Martina Hingis and who played on the golf circuit. This guy was a lawyer. They pass this bill. The state of California now says we will not take into account immigration with any of the licensing. New Mexico has, since I've been back, changed its rules. New York now has done so as well with reform at that level. So I just want to read 4 states. I promise this is going to go very quickly. And I'm doing them alphabetically, so I'm not picking on Texas. In Alabama, if you want to become a lawyer, only a person who's a citizen of the US, or if not a citizen of the United States, a person who is legally present in the United States may apply. In Alaska, you have to be a citizen or provide a social security number. Social security number. Remember what Daca gives you? Permanent residence, social security number, lawful presence. Arizona, if you're not a citizen of the USA, you have to have copies of official documentation of your immigration status. Well, that's pretty easy picking. And then here's the last of the 4, and that is alphabetically. In Arkansas, candidates may be, this is to become a lawyer in the state. Candidates may become a US citizen, alien lawfully admitted, or otherwise authorized to work or study lawfully in the United States. EAD, you got it. So in 4 states picked alphabetically, if you've got DACA, you've got permission to apply for law. Now, they didn't expect that hundreds of people would be applying, but hundreds and thousands of people have been applying to become doctors, which have the same kinds of rules, teachers, school psychologists, lawyers, and hold other occupations that are sort of high end that have post-baccalaureate requirements for them. So we now have, in fact, during the pendency of the last DACA case in Supreme Court, it would, an affidavit was submitted showing that hundreds of these students were actually healthcare workers on the lines tending to people who had COVID. So the service component of these kids just makes them truly remarkable when you consider all the headwinds, the inability to get financial aid, and so forth. And so I'm going to end it there because I'm sure you will have some questions. And I will say, if I don't get to a question or if I don't answer it satisfactorily, or if you want to know where you can buy my book, drop me a note. All you got to do is email me. I'm hiding in plain sight in Santa Fe. I'll go to Isabella if you would give us any questions that have come forward. I probably stunned them all into submission already.
Thank you, Mr. Olivas. Yes, so our first question is from Ernesto. He asks, many undocumented students face challenges in regards to free speech, fear of deportation, retaliation, etc., for speaking out their voices. What do you believe the government and schools should do to protect their free speech, particularly when minority groups are frequently targeted by hate speech?
That's an exceptional question. I was on a phone call one time with several DACA leaders, and I said, if you do that, if you go storm the senator's office and sit in his office, they're going to deport you, and I won't be able to help you. So don't call me at 2 a.m. like I get called regularly to help these students. And he said, you're just an old birthright citizen. I go, God. And there was this loud silence that came over the call. And they said, well, Professor Olivas is our friend. And he said, he's an old birthright citizen. Well, I confess to being old and to being a birthright citizen, although I was born outside the United States. And it is always a balance. And I would say that it's even more of a threat, of course, to undocumented students. I'm not so sure it is to documented students who would still have to, would still have the right to a full immigration hearing before they can be removed because they have lawful presence. So the burden's upon the United States, and very few students lose these kinds of cases. They often get settled, and they win quite often. The Supreme Court heard one about a month ago where a religious zealot was mad because the university had given him a free speech space and then had said he was waving bloody babies. It was anti-abortion free speech. And that's how they often come about. And they eventually allowed him to do so. But I would say that you've got to be careful, just like when you're driving, you got to be careful not to exceed the speed limits and drive with a license and obey laws, because you are in the United States at the furtherance of the United States and with their permission, and you've agreed to abide by the rules, which means no felonies and the like. I think I would never urge anybody not to engage in speech. I think the safety in numbers, if you have a large group, remember the marchas of about 6 years ago, there were hundreds of thousands of people marching on behalf of Daca and Dreamers. So there is some safety in numbers, but I think you must simply be careful because you are technically, you and more importantly, your parents. And because so many Dreamers live with their parents, if the Dreamers are deported, the parents will likely be as well. And all those years invested trying to build up equities and benefits for their kids. And by the way, if they've got minor citizen children, they'll also be deported. They can return when they're 18, but that just completely disrupts their life because the ties to whatever the original home country was are not there, and they're particularly not there if you're born in the United States as one of the younger members of a family. So I would say you do have free speech rights and you ought to assert them. I've been insisting on asserting mine all these years. I've never been arrested, even though I've tried to a couple of times, just like I try and get on jury duty. They never pick me. They never arrest me because they know I'm a lawyer. And so I would say you've got to be careful. Make sure that you do not exceed whatever the bounds are, that you do not assault a police officer or someone. Just like Dr. King went to jail for peaceful protest and wrote letters from Birmingham jail, that was fine. He was beaten in jail, but he wasn't deported. You've got to be careful because your status is still very contingent. So I would say you always have it. I don't need to tell you that you have it in mind. All I'm saying is try and act in a way that will not draw attention to yourself and never, ever transgress the law. It's fine if you're born in Pacoima and they can't deport you, but they certainly can put you in prison. And I just think that you can only do good if you're out and able to be involved in the struggle. And if that is the view of an old birthright citizen, then it is.
Thank you. Our next question is from Linda. She says,
that was one of those kids calling me, by the way.
First of all, she says, thank you for doing the work that you do. It is people like you that have allowed people like me to follow my goals. I have DACA and doing a PhD at UCI. Here's my question.
Wonderful. That's great. Good luck.
What was the wording that you used for the legal liminality of DACA? Was it lawful status versus lawful presence? Thank you.
Lawful status is whether or not you are here on an F-1 student visa or here on an H-1B work visa or with permission with an actual document. But lawful status means that it's in between. It is liminal to be sure, but as long as you're in full compliance with DACA, and DACA remains a program, and no one's asked me yet whether or not it will be enacted. The materials that I've made available and will make available if you write me do show you what President Biden has proposed, and he is trying to give a pathway to citizenship for Dreamers as well as their parents. So that's the answer to that. Lawful status means that you may remain in the United States and you can even leave the country and return with advanced parole permission, but it is not the same as full-blown legal status. Legal status is an articulable document granting status that changes you along this line from coming in temporarily as a visitor or as a student and then applying through marriage or through work or just through the passage of time as a permanent resident, becoming a US citizen. That's status. You don't get that. You get lawful presence, which means that you have permission to remain in the United States and any deportability is left on the side, which will not be enacted against you unless you transgress the rules.
Thank you. The next question is from Quentin. He says, was there ever any law that restricted undocumented children from attending public schools before the 1975 Texas statute that gave way to the Plyer case? It
Yeah.
seems like they randomly tried to restrict undocumented kids from going to schools, even though they were already attending schools throughout the Southwestern states.
Yes, that's an excellent. Quentin was the person's name, or Clinton?
Quentin.
Quentin, okay.
Thank you.
I thought maybe Hillary Clinton was listening in too. That is particularly true along the border where kids would live on the in Matamoros and go to school in Brownsville. They simply cross the bridges every day. And that meant that their parents weren't paying taxes and that those kids were at some risk and they didn't technically live in the school district. And that was, depending on who the superintendent was or who the principal was, that was often observed in the breach. But in the 70s, when school enrollments began simply to soar, particularly after and then after 1986, when so many were coming here in anticipation of legalization, school districts really tightened up because they thought it's only fair that you be a taxpayer and live in the district. Now that led to a case about 6 months after Plyler called Martinez versus Bynum. And this one really is Martinez. And in that one, and Bynum was the head of the state Texas Educational Association. And the case held with exactly the same justices as had decided in Plyler, that a school district could keep a kid out if the parents didn't live in the school district, didn't reside in the school district. It can be proved, like with papers or loan arrangements or whatever, or that they be placed in guardianships, like with your tia or something. The problem with that, of course, is that Mexicanos don't want to cede the authority of their kids even to their favorite aunt and uncle, because that kind of thing can be abusive, and it's a legal process that makes you think like you're giving away your kid, like you're selling beads at a stoplight. It's not culturally, it's just not very popular, even though it's a means of doing this. And I lived apart from my family when I was in the seminary and in high school and then in college. And I didn't, in those days, you had to be 21 to become an adult. And I graduated from college when I was 20. So I was always sort of not on my own. I was entrusted to others who cared for me. But that's very different if it's school children. So the answer to that is it was observed in the breach. Some school districts that needed, because school funds often are on a per head count basis. The more kids you have, the more money you get. Then sometimes they would look the other way. And as I said, along the borders, it was routinely used to keep the enrollments high. Or to provide service, or sometimes it was a mixed family and mixed status where a U.S. citizen was living on the Mexican side, but not on the U.S. side. So it was always very complicated, and that's why domicile and duration are difficult subjects. But remember, Plyler says in a footnote that simply being undocumented doesn't mean that you can't establish domicile in the United States. By the way, for college, think about this. Where do you vote if you're away going to school? If you live in California and you're going to school in Princeton, it will depend. If you live there long enough, there are residency requirements or durational requirements. Normally, the minute that you have a place to live and it's your true permanent fixed abode, that becomes your domicile. But what if you're just there temporarily? And that's the problem with school children that live outside the school districts. I'd be glad to entertain that. That's, by the way, if you're also a graduate student, that's a great dissertation topic. Please go ahead, Isabella.
Well, let me just say, first of all, thank you, Isabella. I wanted to let everybody know that Professor Olivas generously is making his contact information and a number of links related to this topic available. They are now all posted in the chat function. But if you can't get all of them down before the end of the session, Professor Olivas is also very happy to send them to you if you reach out to him through his email address, which we posted in the chat function. Isabella, are there any other questions? If not, I have one that we can close with.
There are no other questions.
Okay.
By the way, you can send your requests with Bitcoins.
So, Michael, one thing that we know is the Biden administration has announced comprehensive immigration reform will be a priority.
Right.
What do you think is likely to happen in the administration as the various kinds of initiatives are rolled out?
Well, it will depend on how many moderate Republicans signal their willingness. Now that Senator Schumer's there running things, the House will probably reenact the bill that they passed and sent that was just simply thrown in the trash can by the Republicans. My guess is it's on the way. I think it will, but you notice how they've already lined up. You know, Senator Hawley has turned his poison now toward this, and others see it as a means of carving something out. But number one. But number two, I do think that he's also announced that Daca will continue. And so for the time being, you'll get the 2-year renewal, and they're taking new applications. You go online, you can Google that, and go to the ICE and CIS the websites, and they spell it out in pretty good detail. And there are even people who will help with the assistance of the $480 fees and so forth, which is now good for 2 years. So that will continue, but at best, it was always a sort of Damocles. It was always sort of a holding pen for people who were waiting for something to change external to them. It had nothing to do with their being in college, because simply being in college wasn't going to get them permanent residence or help them change their status. So what I do think, though, is that because that was closed for 4 years, we have a bunch of undocumented students out there who are eligible. If it was 800,000 the first time around, it must be at least another 500,000 who would apply and then would be able to work with permission, have social security numbers, be able to leave the country and return, and have lawful status, all the benefits accorded by DACA. That's a good interim, but I never saw that as a permanent fix, because it wasn't. The president doesn't have the authority to make a permanent fix. That's why DAPA died. Now, remember, there's still also this case lurking in Texas where Attorney General Paxton has already sued. That will take time, though. I think that the Biden administration is moving very quickly on this. It's got a lot of moving parts to it. And I urge all of you to stay in touch with your elected officials, especially if they're Republicans, to tell them of the importance of this to your life. But please don't go occupy their offices. Don't leave the country and sneak back in just because there's a highlight game in Tijuana. Don't do it. Do it with permission so that you can come back and not be excluded from the United States, which is what will happen. I've devoted my entire personal and professional life to you folks. And I and other advocates on your behalf are trying our very best to make this possible. So your role right now is to apply for DACA, stay in status, do well in school, get a professional license, and start giving back to the community and help your parents, because they subjugated their own needs and desires for bringing you and for your brothers and sisters to do well. And they are heroes. And I believe we finally have an administration that will acknowledge that. And the time is right. Every poll shows that DACA and Dreamers, even in their Republican pollsters, show that there's a substantial population that thinks that these kids are worth it and are an investment. And you are our future. You truly are. And so we have very high expectations from you.
Well, thank you, Professor Olivas, for closing with such inspiring remarks for our audience, as well as an optimistic take. on the future. This was really terrific. We thank you so very much. I just want to thank also everyone who attended and let you know that Professor Tejas' a talk on durable ethnicity, his book, has to be rescheduled. So our next scheduled book talk is going to take place on February 25th. And our speaker will be Rocio Rosales, who will be talking about her book on fruteros. I highly recommend the book as well as the talk. It's a wonderful, deeply embedded ethnography of fruit vendors in Los Angeles. And you get a sense of both the struggles because of immigration status, but also the struggles because of the way that street vending is regulated in Los Angeles. And you come to really appreciate the precariousness of these efforts at entrepreneurship and the ways in which people persevere. So that will be February 25th at 12 noon Pacific time. And thank you again very much for participating.
Thank you all.
And if you want to get the links in the chat function, feel free to write to Professor Olivas if you don't get a chance to access them before this closes. Thanks again. Take care, everybody.